Sir, can you state your name?
Me, Devin Gibson.
All right. All right. What are we doing? You're requesting an adjournment?
Yes, ma'am.
Probable cause conference will be adjourned. It's 2 weeks out, the 10th. April 10th. Will that work for you, Council?
That'll work.
April 10th, 2025, 9 a.m. As your invite indicates, bond will continue.
Right away, this hearing starts with something courtroom regulars recognize instantly: controlled chaos hidden behind routine procedure. Judge Simpson is moving fast. The attorneys are trying to lock schedules, and the defendant is already asking for more time instead of movement on the actual case. But buried inside this calm exchange is the first major signal of the day. Bond is staying exactly where it is. That matters. A continuing bond tells you the court is not comfortable loosening restrictions yet, and in cases involving violence allegations, intimidation claims, or public safety concerns, judges usually treat early release arguments very cautiously. What also stands out here is the tone. Nobody is yelling yet. Nobody is dramatic yet, but experienced viewers know these quiet openings are usually where the real tension begins building underneath the surface. The court is laying procedural groundwork before the prosecution starts detailing the allegations that pushed this defendant into custody in the first place. And once those details enter the record, the entire energy of the hearing changes. Pay attention to how quickly the conversation moves from scheduling into safety concerns and bond conditions. That transition usually means the prosecution believes the defendant is a continuing risk, not just someone waiting for trial paperwork. And once a judge starts leaning toward community safety over convenience, bond reductions become extremely difficult to win.
Go ahead.
18-year-old lifelong resident. He is close to the presumption of innocence in this matter. He do have his father here who support him, so he has significant community ties. He understands that there's going to be no contact between the witness and respectfully honored. My client indicates to us that even if she needs a tether.
Go ahead. You know what I'm saying?
We respectfully request the personal boundary tether, at least to lower it.
Response.
Thank you, Your Honor. First, I want to ask if the court has a copy of the prosecutor's bond recommendation on its file.
I do.
I wanted to ask if the court would go to that. You will see that the authorizing APA on this case originally requested a cash or financial bond of $500,000 cash for surety. I believe that what was actually ordered was significantly reduced amount, if I'm not mistaken, of $50,000 with a 10% privilege on top of that. I think the recommendation form will get into detail about some of the concerns on this case. There is a GPA charge, and there was apparently a very bloody statement in residence, including several counts of RNO with damage to a police vehicle and an intimidation charge as well. So we're very concerned about the safety of the community in general. So the people would ask that it's significantly reduced bond was originally requested.
Anything additional, Counsel? Motion for bond reduction is denied. Bond will continue. Thank you.
That's it, correct.
Court calls
You do
case
that
people
today, girl,
versus
when she put her
Warren.
hands on me, though.
Oh. Do we need it to go back up? Okay, no. Leave it alone? Okay. You're a nicer person than me. All right. Record should reflect we've had a brief bench conference in this case. All right.
Yes, Your Honor, we'd like to set this matter for a
Preliminary. All discovery is complete, Counsel.
Now the courtroom shifts from basic scheduling into a more serious procedural stage: discovery and witness readiness. And this is where viewers sometimes underestimate how important these moments really are. When the court starts confirming whether discovery is complete and whether witnesses are available, it means the case is moving toward real evidentiary examination, not just administrative delay. But notice the atmosphere here. The judge keeps things moving efficiently, almost casually at times, even throwing out little moments of dry courtroom humor earlier. That contrast matters because, underneath the lighter delivery, the accusations being discussed are extremely serious. The prosecution has already hinted at violent allegations, intimidation concerns, 5, and behavior that they believe creates danger for the alleged victim. So while the hearing sounds procedural on the surface, the legal stakes are escalating in the background. This is also where defense attorneys begin trying to humanize their clients before the court hardens its position further. Once a judge becomes convinced someone cannot follow conditions or poses a continuing threat, it becomes much harder to regain judicial trust later in the case.
All right. And is it the 8th? Yeah. And would the people have their witnesses available the 8th? All right. Preliminary examination in person, April 8th, 2025, 9 a.m. That's before Judge Balbo. Bond, go ahead. You want to address Bond?
You were about to say, respectfully, my client's been sitting, my client's been in jail roughly a little bit over 2 weeks now. I do understand that you have previous actions with my client reached out over the phone, but he understands the consequences of those actions at this moment. Respectfully, his phone privilege is revoked right now. He does have a lot of business that he needs to attend to, at least to sort of keep his life going. He's closely presumption of innocence at this moment, and if he is found to be innocent, then his life will be impacted significantly by him sitting in jail, at least not being able to make any phone calls to handle the jail. I do understand these are serious assaultive allegations, but my client is ready to face those allegations, maintaining his innocence in this matter, and respectfully, Your Honor, we're asking the dishonorable court give my client a chance, even if it's with the GPS tether, or even if we at least become more lenient on his phone call, so that he's able to keep his life in some sort of balance while he's locked up.
Response. Judge any modification of bond. As the court heard, he had previous jail calls that weren't addressed that were to the victim after he had been arraigned. He also has numerous dismissed DV cases. He has a detective DV from 2021, another dismissed from firearms and DV.
This is the exact moment the hearing turns sharply against the defense. Up until now, the argument for bond modification was focused on employment, 5 daily life, and maintaining normal responsibilities outside jail. But the prosecution just redirected the entire conversation back toward alleged victim safety. And they did it with detailed behavioral accusations. Instead of vague claims, the prosecutor is laying out a pattern, not just one allegation, not just one emotional incident. A pattern involving repeated violence accusations, forced physical control, intimidation, destruction inside the home, and alleged attempts to dominate the victim during confrontations. And, in bond hearings, patterns matter enormously. Judges are constantly asking themselves one question: if I release this person, what happens next? The defense immediately pushes back, 5 arguing the court should not assume guilt based on prior domestic violence accusations. Legally, that's an important point. Charges are not convictions. Allegations are not findings of fact. But from a practical courtroom perspective, prosecutors know that detailed descriptions of alleged conduct can heavily influence bond decisions because judges are evaluating future risk, not final guilt.
Cases, and in these cases, there's at least 4 instances of him terrorizing the victim, in which he is throwing her around the house, taking her phone, pushing her against the couch, taking her phone again, pushing her on her chest, grabbing her wrist, pushing her around the house, taking her phone again, throwing her down on her stomach, stomping on her back, grabbing her by her hair, slamming her to the floor, and choking her. So I have extreme concerns for her safety and would object to any modification of bond.
That's allegedly, that's allegedly. My client has proven to have performed those actions against that person. And I ask you, please don't use domestic violence cases against my client, or at least assume that he's guilty or that he had something to do with those cases. Because if we want to make assumptions, we could assume that somebody may be lying on him and trying to use the police against him because of what they might be going through in their relationship that's not assault of marriage. So, respectfully, Your Honor, we're looking at this case on his face. I do understand his sort of nature. I do understand he had that phone call. But my client got his phone call revoked. Not able to speak to anybody. Been sitting in jail over 2 weeks. He understands the severity of those.
Yeah, but that's by his own due. I mean, it's not as though we just decided to sort of hold him incommunicado. The problem is that he couldn't follow the conditions as we laid them out. So if I released him, what would make me think that he would follow any of the conditions that are set right now? He didn't do it before.
There's ways to mitigate that, Jan. There's ways to mitigate that with the GPS tether. Even if it's house arrest. With a GPS tether. If he steps out of that house, then he's gonna be arrested.
Couldn't follow the conditions when we first gave him to him. Motion for bond reduction denied. Bond will continue.
And there it is, the ruling the defense absolutely did not want to hear. Judge Simpson is making it crystal clear that the issue here is no longer just about release conditions. It's about trust. Specifically, whether the defendant has shown any ability to follow court-imposed restrictions once already given the opportunity. The judge's reasoning earlier was extremely important. He basically said, if prior conditions were ignored before, why should the court believe new conditions would suddenly work now? That logic is devastating during a bond hearing, because once the court believes a defendant cannot comply with orders, even stricter supervision tools like GPS monitoring or house arrest start losing persuasive value. What's fascinating is that the defense tried multiple angles: employment obligations, innocence claims, structured monitoring, limited movement. But the prosecution kept bringing the argument back to alleged contact violations and safety concerns. And in cases involving alleged domestic violence or intimidation, judges often treat unauthorized communication as a massive red flag because it suggests court authority itself may not be taken seriously.
Thank you. Courthouse case, People versus Jacob Potter.
And on behalf of you.
Yeah. Is that who they have?
Am I right? State your name for the record. Jacob Potter.
Thank you.
This time we're going to respectfully requesting the sentence for a preliminary exam.
All discovery is complete.
My apologies.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, April 8th, 2025, 9 a.m. That's before judge.
Can I address bond briefly?
You may.
My client is going to be asking for a PR bond. He has a place in Belleville where where he will be staying with a friend over on Rustic Drive. It's going to go on a tether if the court deems that necessary. He just wants to get back to his job. He works at public disposal. So 50 hours a week there. He wants to get back to his job. So
Yes.
Your Honor, I was also going to ask the court to address bond, as he has made 52 calls to the victim from his pen since arraignment. In these calls, he says, you got to go to the prosecutor's office and tell them it's not written down right, that I lived there too. I damaged the door, they're making it look like I just entered the place, I've never been there before, and that I'm your ex-boyfriend. He also says, go to the prosecutor's office and speak on our behalf, whatever, I can't talk to you. He also says, this is a serious issue, I don't know if you can help, I don't know if the prosecutor tomorrow or anything, I don't know. You need to leave your number out, anything you may sign, you know what I mean? If you, or the prosecutor or anything, leave your phone number out, anything that you might sign, that way they can't link.
These jail call allegations are becoming a major problem for the defense, and the prosecution knows it. The state is not just accusing the defendant of making contact. They're presenting the calls as evidence of intentional attempts to work around monitoring systems and influence the alleged victim's behavior. That changes the entire tone of the hearing. Listen carefully to what the prosecutor is emphasizing. Coded communication, requests involving the prosecutor's office, discussions about phone records, and suggestions about using applications the jail supposedly cannot monitor. Whether every allegation ultimately proves true at trial is a separate question entirely, but during bond proceedings, the judge is evaluating risk and compliance right now, not months later after a jury hears evidence. The defense tries reframing the situation as misunderstanding and logistical communication. By 5. But the prosecution is framing it as manipulation and deliberate evasion. Those are two radically different narratives. And judges often react strongly when they believe someone is actively trying to bypass court restrictions while already in custody.
Due to my call history, and then he also asks her to get on the TextNow app they have in the jail because we can't see that, and that's why he wants to keep communicating with her. So I have extreme concerns that he can't follow court orders and reject any modification.
I understand your Honor. I briefly spoke to him. No contact. He understands that there needs no contact, period. He just wanted to somehow get the information to the court that he lives at the address. Questions. But
He wanted to get that communicated to the person that does live at the address? That makes no sense.
I will just add that when he was at that address, he kicked the door open and entered the house without permission, and he began throwing her items against the wall and motion prosecuted them. So I have extreme concerns of the people getting here by that.
Defendant's phone privileges are revoked. Defendant's motion for bond reduction is denied. Bond will continue, but his privileges are revoked.
understood, Your Honor.
Thank you. Court does call the cases of People versus Beverly Boss. They need to sign off.
This is public defender Natalie. Probably went and on behalf of Ms. Boss, who should be dialed into Zoom, Your Honor. She called the public defender's office this morning. She talked to several of the legal assistants. She's actually sick and she was having trouble logging onto Zoom, but I believe she was finally able to successfully dial in. If she's using her father's phone, the last three numbers would be 238.
Nope. I have one call in.
I'm not sure if that's the number she's using. If it's her father's phone, it would be that number.
Ms. Boss, if you called in on Zoom, I only have one number, but if you called in on Zoom, you'll need to hit *6 on your phone to unmute.
This section feels almost chaotic compared to the earlier hearings, but it actually reveals something important about modern court systems. Remote appearances, technical issues, unstable communication, delayed attorney contact, all of that can create confusion that spills directly into active criminal proceedings. Judge Simpson is trying to maintain control while also figuring out whether the defendant is even properly connected to the hearing. Once the defendant finally speaks, the court quickly moves into discussions about substance history, tether issues, probation concerns, competency restoration, and prior custody experiences. That is an enormous amount of legal and personal history entering the courtroom at once. And you can tell the judge becomes especially focused once the conversation turns toward alleged tampering with monitoring devices, while apparently not currently being placed back on one. The judge's reaction says everything. He openly questions the logic of someone accused of tampering with a tether not being placed back under stricter monitoring. That kind of judicial skepticism can completely shape how future bond decisions unfold.
Hello?
Oh, hello, what's your name?
Hello. Beverly Boss?
Okay, that's her.
Awesome, thank you.
Yeah, that's me.
So, Your Honor, I have discussed this matter with people. I was planning, Ms. Boss and I have not been successful in having a phone conversation prior to today. I was going to give her an update this morning, but she obviously was unable to be accomplished. I would ask her to tell me loud. I understand if 2 weeks.
It's going to be 2 weeks.
I understand, Your Honor. Thank you.
Nice try, though.
Your Honor, no objection, but I do want to inquire about bond.
Oh, boy. Probable cause conference, April 10th, 2025, 9 a.m. Yes, as to bond.
Your Honor, so Ms. Boss, as the court is likely aware of the nature of the case, has a longstanding history with, I think, multiple substances, including alcohol. One of these is an OWI case. I think it's her. As one of these counts relates to the.
No, I don't.
Yeah.
I don't have an OWI.
Oh, it isn't. I'm sorry. One of these counts relates to the removal of a scram tether for such a case. I
Got it.
am inquiring if she is currently on an order. I saw that when she was arraigned on these cases, that I didn't see a community corrections order for her. So given the nature, I think, of the charge, that I want to make sure she says it.
Ma'am, are you on a scram tether?
I was on a scram tether, and I had, and a long time ago, and something had, I thought it was in the cases with what we are going through now. It was a part of the bond too. I bonded out on the cases.
This exchange is one of the more complicated moments in the entire hearing because everyone in the courtroom is trying to untangle overlapping cases, probation issues, tether allegations, competency proceedings, and bond history all at once. And when that happens, judges usually start simplifying the issue down to one core question. Can this defendant safely comply with court conditions moving forward? The defendant is trying to explain prior circumstances involving jail time, a tether issue, and what she believes happened procedurally in earlier cases. Meanwhile, the defense attorney is emphasizing that competency restoration has already occurred and that no current tether order appears active in these specific matters. But Judge Simpson seems unconvinced by the overall logic of the situation. What makes this especially tense is that the judge openly acknowledges the inconsistency he sees. When a judge starts verbally questioning how prior supervision allegedly failed, it signals concern about accountability and enforcement. Even if the legal explanations technically exist somewhere in the record, the courtroom perception still matters enormously.
Okay, but are you on a scram tether right now?
No, I'm not on any kind of tether.
I believe that is correct, Your Honor, that she is not on a screen tether or on the order to be on a screen tether, my understanding.
Okay, so how's somebody get out for tampering with the device and then not get put back on the device if that were?
So that was on
I'm sorry for being too logical. Yeah, go ahead.
So that was for another case that she was on probation for in circuit court. Then allegedly something happened with that scram tether, which then the charge initiated. She has been on bond in both these cases for some time, previously referred for competency, was at the forensic center, was found incompetent but restorable, has been restored. It's now a finding of competency. That being said, I don't believe she was ever under any order in either of these cases, to my knowledge, to be on a scram tether. And none of the charges in either of these cases are an OWI.
So, but
Yeah, that don't make sense. I did a year in the county jail. I got my tether cut off. And then I did 365 days, turned around, did another 6 months. And then they pulled up charges on me for tampering with my tampering device. But me and my lawyer and the safe house with the other judge, I think it was non-prejudice to come back at me with the tether tampering. So all of a sudden, they just...
Okay. I got it. I'm not going to change anything. I'm just going to leave it where it is because I see the dates, and so bond will continue.
Thank you, Your Honor.
what was the date, Your Honor?
Yes, ma'am.
What was the date again? April what? 9th or 10th?
April 10th. 2 weeks from today.
This moment almost feels deceptively calm after everything the court has just discussed. But these scheduling confirmations matter because they officially lock the defendant back into the next phase of proceedings while keeping all current 5 bond conditions intact. In other words, nobody walked out of this hearing with meaningful relief. Judge Simpson has now repeatedly shown a consistent pattern throughout these cases. If there are allegations involving ignored conditions, 5 unauthorized communication or supervision failures, he is not eager to loosen restrictions. That judicial philosophy has shaped nearly every ruling we've heard today, and from the prosecution's perspective, they successfully kept the court focused on compliance concerns instead of sympathy-based arguments. What's interesting is how many defendants in this hearing tried emphasizing ordinary life pressures, jobs, responsibilities, housing situations, by 5 family support, daily obligations. Those arguments are emotionally persuasive because they humanize the accused. But courts balancing public safety concerns often prioritize enforceability over personal hardship, especially when prosecutors present allegations suggesting court orders were already disregarded.
Okay, thank you, sir.
Thank
Thank you,
you.
Your Honor.
Thank you, Ms. Boss. We'll be in touch again.
Okay, thank you.
Court calls the cases of Court calls the case People versus Jeffrey Stoops.
Does that have active people, Your Honor?
The public defender, Beverly, on behalf of Mr. Stoops in the case ending in 1740.
Your name, sir?
Yeah, good morning. My name is Jeffrey Allen Stoops.
All right. You're requesting an adjournment.
I am, and I do believe Mr. Drugas did state to me he was requesting an adjournment in my case, or in his case as well. Mr. Stoops has been referred in my case to the 14B recovery court. I've been in contact with Mr. Ray's down there. He has not yet been down to jail to screen Mr. Stoops, but he states he is going to. I believe that'll be done sometime early next week. So I'm just requesting a 2-week adjournment of my case.
I have the written form. Where's Mr. Drukas?
Right in the hallway.
You didn't say he was going to adjourn it at all.
Yeah, I know, but I have his client. I need the attorney. I mean, hey. Mr. Drukas, you're requesting an adjournment also on Mr. Stoops? Yes. All right.
Your Honor, if people could drop out for
Yes. Hold on one moment. So how much time? There's a referral that has gone over to 14B. I presume you're tagging along with that. So where is it in that process?
I would just ask for 2 to 3 weeks, Your Honor. Mr. Ray hasn't met with Mr. Stoops yet, but said that it's on soon. So I don't know for sure if he had been answered in 2 weeks, but I would ask for 2 to 3 weeks.
All right. Why don't we do the April 17th,
Thank you, Your Honor.
2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to our attention that he has made 51 calls since his arraignment to the victims. He's been calling his phone when it is the victim that answers. In talking, they use a code name calling her Aunt Diane, but it's the victim. So we would have concerns that he's contacting her by using his own phone number, and that's his phone for the phone.
With regard to that, I haven't heard anything so.
Any response to that?
No,
You're
Your Honor,
presuming it's not on your case.
So, yes, I would check her.
Well, you'll be entitled to certainly file a hearing once you hear all of the calls, but at this point, I'm going to revoke the defendant's phone privileges. His bond in each of these cases will continue.
Thank you, Your Honor.
This final hearing segment perfectly summarizes the broader theme running through the entire day inside Judge Simpson's courtroom: supervision, 5 compliance, and judicial trust. Even when defendants request adjournments, recovery court referrals, or bond modifications, the court keeps circling back to the same concern: whether court orders are actually being respected outside the courtroom walls. Here, the discussion about alleged coded communication with the victim immediately shifts the focus away from treatment opportunities and back toward 5 compliance concerns. The prosecution argues the defendant was still communicating despite restrictions, while the defense signals that additional factual hearings may be necessary later. But Judge Simpson ultimately makes the decision that matters most right now: privileges revoked, bond continuing. That ruling reinforces the consistent message we saw throughout these proceedings. The court appears willing to give structure, process, and future hearing dates, but not increased freedom where alleged violations continue surfacing. And for defendants hoping to regain trust, that becomes an uphill battle very quickly. Overall, today's hearing showed how bond decisions are rarely just about one accusation. Judges weigh patterns, behavior, compliance history, communication attempts, safety concerns, and credibility all at once. Judge Simpson repeatedly sided with caution over flexibility, and that shaped nearly every major outcome we witnessed today. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.